Members, if everyone would get logged into the system, please. We'll get started right here in just a minute. Is every member logged in? I'm going to go ahead and.
Just make sure your mic's on, or your mic is on. So we're ready when you are.
Good morning, everyone. We'd like to call this meeting of department and agencies to order and welcome everyone here today. We have a pretty good sized calendar. However, we do have several bills that have been asked to be rolled and a couple taken off notice. So without objection, we'll do a little housekeeping first. So first up, we have House Bill 1947 to be rolled 1 week without objection. House Bill 1639 rolled 1 week without objection. House Bill 2018 rolled 1 week without objection. House Bill 2449 rolled 1 week without objection. House Bill 2245 rolled 1 week as well without objection. Bills off notice is HJR 794 is taken off notice. House Bill 2287 is off notice. And with that, does any member have any personal orders before we get started on our calendar? All right, well, I guess we better take roll though, hadn't we? So, Madam Clerk, if you would open the board for the roll. All right, Madam Clerk.
Mr. Chair, you have 6 members present. You have a quorum.
Thank you.
So, I hate to do this to you. Since we one at a time. I'm sorry, I should have caught you.
Okay. Ladies and gentlemen, I believe I'm going to have to do that one again on the off notice and the rolls because I apparently did not have a quorum when I announced that. Okay.
We can just
Okay.
this way.
Okay. Off notice will be, roll 1 week was Bill 1649 without objection. 1639, I'm sorry. House Bill 2018 off roll 1 week. House Bill 1947 roll 1 week. House Bill 2018 roll 1 week. House Bill 2449 roll 1 week. House Bill 2245 roll 1 week. And off notice is HJR 794 is off notice. House Bill 2287 is off notice. So if there are no personal orders, we're going to get started into our calendar. And I would like to go out of order on item number 3, House Bill 1753 by Chairman Howell. We have a motion. We have a second. Chairman Howell, you're recognized.
This bill came to me from the Tennessee County Commissioners Association. The bill does not change the law. It simply adds an education component to existing law. We learned that during Helene, a major declared disaster in East Tennessee, that apparently many counties did not know that we have blanket mutual aid. And some counties may have wanted to help and assist other counties across the state, but we're not aware that they could do that. So there is blanket mutual aid already in code. This bill just simply says that all 95 EMA agencies in every county will make this a part of their continuing education. That's all it does.
Chairman, I noticed there is an amendment that does rewrite the bill, so we need to get that on the bill for you.
I believe I have, is it 13674? Is that right?
That is correct.
Thank you.
Do we have a motion on the amendment? We have motion and second on the amendment. All in favor of adding the amendment to the bill, say aye. Any opposed? The bill is amended, and thank you for your explanation. Is there any questions? Okay. Is there a question? Seeing no questions, Chairman Crawford.
Move previous question.
Previous question has been moved. Without objection, we will open the voting board, Madam Clerk. And everyone cast your vote. Anyone wishing to change their vote? And okay. We'll give you that opportunity, Chairman Powers.
Thank you.
Thank you. Thank you. Madam Clerk, if you would announce the vote.
Mr. Chair, you have 8 ayes and 0 noes.
The ayes have it, sir. You move on to full state and local. Thank you. Next up is item number 2, which is House Bill 1533 by Speaker Marsh. Do we have a motion? We have a second. Chairman, or Speaker Marsh, you're
Thank you, Mr. Chairman. I do have an amendment,
recognized.
drafting code 14346, which makes the bill.
Okay, that's what we have. Do we have a motion on the amendment? Second on the amendment? All in favor of adding the amendment, please say aye. Any opposed? The amendment is on the bill, and Speaker, you're recognized.
Thank you,
to
Mr.
present your bill.
Chairman. As amended, House Bill 1533 makes a consumer-friendly update to Tennessee's alcohol laws by allowing ready-to-drink spirit-based cocktails to be sold in the same retail locations where beer and wine-based RTDs are already available. Today, beer and wine-based RTDs can be purchased in grocery stores, convenience stores, and liquor stores, but spirit-based RTDs, despite having similar or lower alcohol levels, are restricted only to liquor stores. This bill corrects that inconsistency by creating a supplemental ABC license and limits sales strictly to RDTs with 10% alcohol or less in the stores. Tennessee is one of only 15 states that does not allow spirit-based ready-to-drink cocktails to be sold in the same stores that already sell beer and wine-based RTDs. In practical terms, that means a shopper looking for a canned margarita can find the malt-based version with the same alcohol content at a grocery or convenience store, but not the version made with actual tequila. That difference isn't based on alcohol strength. It's based solely on how the alcohol was produced. What this bill will not do, it does not allow full liquor sales in grocery stores. Similar to the wine and grocery store bill that we passed in 2014, it does not remove these products from package store shelves. In fact, since wine was expanded in 2014 to grocery stores, the number of package stores has grown from approximately 600 to 874, 274 additional package stores. And the package stores' tax collections increased 56% during that time, showing that it doesn't hurt our business and our taxes. Most importantly to me and to hundreds of employees at Jack Daniel's who live in my district, and Jack Daniel's makes their product in my district, this bill will provide an economic shot in the arm for Tennessee distillers who are seeing a decline in sales outside of RTDs. I respectfully ask for your consideration, and I do have some people that would like to testify, if you don't mind.
I don't mind a bit. Members, we're going to go out of session to hear from some testimony. I believe we have Matt Caudill and Charity Toombs here. And if you all would come up, we are out of session. And just make your way up here. And your all right.
Let them know how much time they've got.
And you will each have 3 minutes for testimony. And she'll turn your mic on. Do you have a preference on who goes first? Okay, all right. Matt, you're up. If you would just state your name and who you're representing.
Thank you, Mr. Chairman, members of the committee, especially Representative Langford, who represents some of our territory. My name is Matt Caudill. I'm the general manager for retail operations with Beach Oil Company. We're a family-owned business. We operate 20 convenience stores in the Clarksville area. And along with other members of the Tennessee Fuel and Convenience Store Association, we would just ask for your support in House Bill 1533, or commonly referred to as the ready-to-drink parity. Ready-to-drink cocktails are one of the fastest-growing beverage categories in the country. Consumers want them. Spirit-based RTDs typically contain the same or even less alcohol than beer or wine-based RTDs. Demand is strong. Even major beer companies now make spirit-based RTDs to stay competitive, but the Tennessee law treats these products differently. Grocery and convenience stores can sell beer and wine-based RTDs, but they cannot sell the spirits-based RTDs. That does not make sense. It confuses consumers, and it puts Tennessee retailers at a disadvantage, especially compared to neighboring states. This bill offers a limited and responsible fix. It creates a supplemental ABC license for grocery stores and convenience stores. It does not allow full liquor sales in grocery or convenience, and I'm not aware of any that want that in the first place. It limits sales to RTD products that follow beer regulations. This is not a major change to our alcohol system. It's a simple update. It establishes fairness between similar products. 32 states already allow spirits-based RTDs in grocery. 30 of those allow it in convenience. In 2014, obviously, wine and grocery became a reality in the state of Tennessee. As referenced earlier, package stores actually grew after that time, as well as package store tax collections increased by 56%, which just proves competition is good for business. Retail markets change, consumer preferences change, traditional spirit sales are declining, alternative products are growing. Retailers should be able to respond to that demand. We operate convenience stores, and in this situation, the convenience is for the consumer. They're asking for these items to be available so that they can stop at a store, get their fuel, their ice, their snacks, and the drinks that they want without having to load back up, go somewhere else to be able to make that transactions. The other part is that the RTDs are packaged just like beer and other RTDs, the wine-based RTDs. Single serves, 12 packs, and the consumers don't understand why they're not able to do that. RTD parity is good for Tennessee. It keeps our retailers competitive. It supports consumer choice, and it drives additional sales. I respectfully ask for your support for House Bill 1533. Please vote yes for the ready-to-drink parity. Thank you for your time. And if anyone has any questions, I'll do my best to answer them.
Thank you, and we'll come back to that.
Okay.
I will give time for questions for both of you. And that was perfect right at 3 minutes. Perfect. So next, we'll hear from Charity Toombs and if you would, just your name and who you represent.
Absolutely. Good morning, Chairman and members of the committee. My name is Charity Toombs. I am the Executive Director for the Tennessee Distillers Guild. Thank you for the opportunity to speak on behalf of the Tennessee Distillers Guild and the men and women who produce our state's world-renowned spirits. I'm here in support of allowing spirits-based ready-to-drink cocktails to be sold in grocery and convenience stores. For Tennessee distillers, this issue is about opportunity during a challenging time for our industry. The ready-to-drink category is the fastest growing segment of beverage alcohol. Consumers are looking for convenience and consistency, and Tennessee distillers, both large heritage brands and small craft producers, want to meet that demand. But under current law, spirit-based RTDs do not have the same retail access as other beverages and comparable alcohol content. That limitation matters, especially for our small craft distillers. Across Tennessee, small distilleries have become important local employers and tourism drivers. They support Tennessee grain farmers, they create jobs, and they contribute to the character of their communities. For many of them, an RTD is more than a product line, it's an entry point, a way for new consumers to experience a Tennessee-made spirit in an accessible format. Expanded access to grocery and convenience stores means visibility. It means thousands of additional storefronts where a small Tennessee brand can introduce itself to new customers. Importantly, some of our small craft distillers are not currently producing RTDs. That is not because of the lack of interest or innovation. It is because the current retail limitations make the investment difficult to justify. Developing and packaging an RTD requires capital. When access to market is restricted, many small producers cannot take that risk. If the law allowed broader retail access, many of our distillers would explore entering the RTD category. That means new production lines, new supplier relationships, and most importantly, new jobs here in Tennessee. We want to be clear, this proposal is not about increasing alcohol content or expanding high-proof products into new channels. Most spirit-based RTDs contain alcohol levels comparable to products already sold in these locations. This legislation simply allows Tennessee distillers to participate fairly in a category that is already established and growing. This legislation supports Tennessee agriculture, it strengthens our small business, and reflects a thoughtful modernization of our laws. Most importantly, it gives Tennessee craft distillers the opportunity not just to maintain their business, but to innovate and grow here at home. Thank you for your time and consideration today.
Thank you both for your testimony. And members, are there any questions for our guests? Don't see any questions, so thank you all both for being here. Thank you. Speaker Marsh.
We need to go back in session.
Well, we're back in session.
Thank you, Mr. Chairman. There was another person on the list that came in from out of town that wanted to say a few words. Do you have him on your list?
I only have the two
Corey.
speaker.
Didn't have Corey? Okay,
No,
I'm sorry.
sorry. They actually did submit the form, and they said if they choose to be, if they want to be, they're here if we want them to come up. So I have no objection if they want to come up.
Drove in today, I think a few minutes would be good.
He is on the list, but it just as needed. So we're back out of session. And if you would just identify yourself and who you represent, and your mic will be on right there in just a second. Right there you are.
Thank you, Mr. Chairman. My name is Corey Sinisi, and I'm with the Distilled Spirits Council of the U.S., and we're in support of this item. Alcohol is alcohol. It should not matter whether the beverage is made with alcohol from grapes, malt, or grains. The ingredient or the process that makes the chemical element of alcohol should not be the determining factor on where these products can be sold, but rather by their alcohol by volume levels. Ready-to-drink spirit coolers, as you've heard, are low-alcohol, pre-mixed canned cocktails made with small amounts of distilled spirits that adult consumers want, especially as moderation becomes more and more prevalent. Today, package stores are the exclusive retailers of these low ABV spirit products, and they so desperately want you to help them maintain their government-mandated monopoly on them. But here are some of the facts. In my home state of Florida, where I flew in from today, where RTDs are allowed in the same way that we're discussing, Package store employment has increased 30% between 2019 and 2024. In Mississippi, also allowing for these expanded RTD sales, we saw a 20% increase in package store employment. Tennessee stores also have seen 20% growth in that same period, even with the wine and grocery stores. Our economist also states, based on the data we see in sales across the country, it is far more likely that expanded distribution would generate new sales of spirit-based RTDs rather than simply shifting sales from liquor stores to grocery stores. This means that a consumer is more likely to simply swap out a malt or wine-based product for our spirit-based products at a grocery convenience store, not necessarily equating to more alcohol in circulation. Meanwhile, this gives Tennessee an estimated $9.9 million per year in added tax revenue when the consumer chooses to make that switch from malt to spirit-based RTD product. And people still seem to make the same purchase at liquor stores for premium full spirits. Exclusivity is good for their business. It's not necessarily good for freedom, especially with franchise protection that keep the manufacturer beholden to the distributor. We're not taking these beverages away from package stores. We're simply allowing other retailers who already legally sell lower ABV alcohol to join the package stores in healthy competition and only add these low ABV spirit products in their inventory. Appreciate you today, and thank you for letting me jump in here.
Thank you. Thank you very much. Is there any questions for our guest? Seeing none, thank you for coming. And we will go back in session, and Speaker Marsh, you're recognized.
Thank you, Mr. Chairman, and thank you for allowing him to testify. And I also heard from Jack Daniels in the last week or so, if this is approved, they're going to take all their RTRs from 7% to 5% in this summer. So the alcohol content will be even lower. So I appreciate your positive outlook on this bill.
Thank you. If we have any questions for, Representative Martin.
Martin.
Sorry.
That would be
Sorry.
Martin. That's okay.
I'm butchering names today.
That's as long as you're not butchering me.
Okay.
You can butcher my name. I don't know, Mr. Chairman, if my question is for the sponsor or it's for legal. I'll let you determine that. But my question is this. When the state did the wine and grocery stores bill, that was a referendum that was county by county, I believe. And is that a true statement that it was done? I know it was a referendum because I remember I had a son who worked in a grocery store and got all kinds of signatures to allow. Was that county by county? Do you know that, Speaker Marsh?
I don't think it was. I think we did it up here in the legislature. I remember it was a big fight for several years. I think what they were doing were getting signatures to ask us to approve it, but I don't think it was a referendum. I could be wrong, but I'm not sure.
Okay.
It wasn't.
It wasn't a referendum. Okay, that's fine.
Okay.
Thank you.
Okay. All right. So that you're good then? I'm good. Okay. Anyone else? Seeing none. Is there call for question? Guess we're ready to vote. Madam Clerk, if you would, open the board for voting. Madam Clerk, if you would, take the vote, please.
Mr. Chair, you have 0 ayes, 7 noes, and 1 present not voting.
Speaker Marsh.
I guess we'll still go to the liquor stores to get our Jack and Coke. Thank you all for hearing me out.
Thank you, sir. The bill, just for the record, House Bill 1533 has failed. Next up, we have item number 4, House Bill 1884 by Chairman Subcommittee. We have a motion. Do we have a second? We have a second?
Second.
We have a motion and a second, and Chairman Subcommittee, you're recognized on House Bill 1884. And I believe it does have an amendment. Is that correct?
I do not believe so, Mr. Chairman. Is it 013419?
That's correct. It
Okay.
rewrites the bill.
There you go.
Okay.
There you go.
Okay. All right. We'll go ahead and get that on there. The motion, we have a second on the amendment. And we're all in favor of adding the amendment. Please say aye. Any opposed? the bill is amended, and if you would, Chairman Sapicki, just tell us about your bill.
Thank you, Mr. Chairman. The first thing I would probably like to make a motion that we turn the air conditioning up in these committee rooms. It is,
Turn it up.
it is up. It is, or down, whatever you want to say. It is unbearable. Members, very simply, what this bill does, it prohibits a state agency from issuing or renewing a certification, a registration, a license, or a permit to a corporate entity if an officer, director, or employee of that corporation provides material support or resources, including providing meeting spaces or other forms such as electronic or print platforms for the purpose of soliciting material support or recruiting new members to a designated entity, a group that is found to have engaged in terrorism, or a group that receives support from a designated entity. That's what the bill does, Mr. Chairman. I'll be happy to answer questions.
Thank you. Is there any questions for the sponsor? Seeing none, Madam Clerk, if you would, open the board for voting. Has everybody voted? Anybody wishing to change their vote? If not, Madam Clerk, if you would, announce the vote.
Mr. Chair, you have 8 ayes, 0 noes, and 0 present not voting.
Okay, Chairman Sapicki, you move on out to full committee. And next up, we have item number 5, which is House Bill 1885, also by Chairman Sapicki. Do we have a motion? We have a motion. Do we have a second? We have a second. Chairman Sapicki, you're recognized on your bill.
Thank you, Mr. Chairman. I do have one amendment. It is drafting code 012959, which is a friendly amendment.
959,
9.
okay. All right.
It makes the bill. It does not rewrite it.
Okay, all right. Let's go ahead and get the amendment on the bill. Motion, we have a second, and all in favor of adding the amendment, say aye. Any opposed? You're on your bill as amended. If you would, go ahead.
Thank you, Mr. Chairman. And first of all, just to let you know what the amendment you just put on did is clarifying language on defining what currency is in regards to the bill. That's all it did, just a definition part of the bill. Members, this bill does not change any law in the state of Tennessee. It just creates a greater enforcement mechanism. And we have the State Gaming Board here and the Attorney General here that will opine deeper for your questions and concerns about this bill. The first thing I want to say to you, and I'll repeat this as we go through the process here, is that if you are following the law in Tennessee in regards to gambling, this bill has no bearing on you whatsoever. If you are operating in the gray or potentially operating illegally gambling in the state of Tennessee, you should have concerns because now this expands the scope of enforcement, not only partnering Sports Wagering Commission, but now brings the Attorney General's resources on board to make sure that if we have gambling in the state of Tennessee, the law is being followed to the nth degree. This bill addresses the pervasive and growing problem in Tennessee of illegal online sweepstakes casinos and other forms of online gambling that are often marked as illegal or as legal, free-to-play social gaming platforms utilizing a promotional sweepstakes model and illegal, unregulated, and unlicensed gambling machines. This legislation designates illegal gambling and related activities as violations of the Tennessee Consumer Protection Act and expands the investigative authority of the Attorney General to investigate such unlawful activity. This bill does not change the enforcement mechanisms already available under the criminal code. Local law enforcement will still have the authority to prosecute illegal gambling and gambling machines. Mr. Chairman, we have State Commission and the AG here willing to testify about the bill, and I'm sure if you have any concerns, answer your questions.
We do have other testimony as well, so if the members wish to call them up, we will. And but we do have Bill Gantz to testify, so we'll go out of session, sir, if you want to take a seat here in front of a microphone. And if you would, just state your name and who you represent for the record. And you do have 3 minutes.
All right, thank you.
Okay.
My name is Bill Gantz, and I'm here as a witness today on behalf of VGW, which is a freemium social gaming operator. I am an attorney. I have 25 years of experience representing internet gaming companies. Without stating why, this bill concludes at the top end that the online sweepstakes casinos as defined are illegal. If that truly were the case, then changing the law would not be necessary. What we're talking about here are freemium games that have a casino theme. These games have been around for over 10 years. They were introduced in 2012, including VGW's pioneering social games. Many of the operators of these freemium types of games are publicly traded licensed gaming companies. They do business, and they have done it since 2012. No purchase is necessary to play a freemium game or to continue playing a freemium game. These are freemium games. They include not only those with casino themes, which are the target of the proposed legislation, but games like Candy Crush, Bejeweled, Subway Surfer, and a lot of other really popular titles. And those will continue to be lawful in Tennessee because freemium games that I've described are a bona fide product. They've been around for a long time. And because of that, they can be promoted using a sweepstakes under Section 471824. And that's why using a sweepstakes to promote games is commonplace. Because McDonald's sells a cheeseburger and gives a pull tab game in connection with that, that doesn't make it illegal. If Starbucks uses an instant win game on their app to run a game to give away things on their app, that doesn't make it illegal. It makes it a sweepstakes because no purchase is necessary to enter or win. Very importantly, there has been no study. So on VGW's platform, the vast majority of users don't make a purchase, and those who do make a minimum purchase. The median spend is about $25 a week. This is not gambling. And the most important thing, because there haven't been an opportunity to discuss the product or make presentations in detail, is that the sweepstakes entries into these games in the form of sweeps coins, they can never be purchased on the platform. They are awarded for free in connection with a purchase, just like any other sweepstakes. They are awarded for free for logging in. They are awarded for engaging in social media that many people do. And they also, like all other sweepstakes, have a standard write-in alternative method of entry, entering for free. HB 1885, as applied to online sweepstakes, changes the law.
Sir, I'm
Yes, sir.
3 minutes is we're at the 3 minute limit on testimony.
All right, may I conclude briefly, sir?
If one of the members has question, I'll be glad to let you do that. Any minute? Okay, Representative Miller.
Thank you, Mr. Chairman. Mr. Gant, a question in reference to VGW. Are you all licensed and regulated in the state of Tennessee to operate?
There is.
Mr. Gantz, I'll need to recognize you on that, okay? So,
Sorry.
Mr. Gantz, you're recognized.
All right, thank you. There's no license or regulation available for companies that operate sweepstakes, but they must comply with the existing sweepstakes statute, which is, as I mentioned, is 4718-124. They cannot require a purchase in connection with operating sweepstakes, which VGW does not.
Representative Miller.
Again, for clarification, you say that the state cannot require it?
There just isn't a category of licensure available. If there were a registration.
Mr. Gantz, your mic's not on, so you're recognized.
All right, I'll catch on eventually.
Okay.
All right. There just simply isn't a category for registration available. Had there been more time to have discussions, VGW would be pleased to have a discussion with representatives about a registration process. You can change the law to allow the collection of digital sales tax on a taxable item like entertainment. It's just that the law doesn't currently allow for that. But there's been one committee meeting. There hasn't been really any opportunity to go into this in depth. And this legislation originally was about combating the sweepstakes kiosks and machines. That's not our business, and we have no stake in that whatsoever. But that's really the main issue. So we think it would be appropriate to have a pause or to table this so items such as you've raised, Representative, could be discussed.
Very good. Thank you. Chairman Crawford.
So you were talking there, does that mean that you guys are licensed in the state of Tennessee or?
No, there's no.
Mr. Gantz, you're recognized.
All right, thank you. Representative, there's no current license granted by the state of Tennessee to any company that wishes to operate the freemium games or wishes to add a sweepstakes to it. It is a form of unregulated gaming, just like Candy Crush or Subway Surfers. There simply isn't a registration. If there were one, VGW would be more than happy to fill it out and pay sales tax if that were authorized by the state of Tennessee for digital entertainment. It's not at this time. Digital goods, yes. Digital entertainment, no. So that's the type of discussion, if we had more time to present our product and its category and its size in Tennessee and around the country. It's a big part of people's lives to play these games. We think we could have a rational and a good explanation for why that ought to be included in as part of a licensure process or registration process.
Chairman Crawford.
So is there any states that surrounding us that do have a license program?
Mr. Gantz.
There is not. There is not. And most states haven't addressed this issue at all. And people can play freemium games and enter into sweepstakes as they were before without any type of regulation, other than, of course, complying with the sweepstakes laws, which VGW does. It does not require any purchases in order to make an entry into the sweepstakes. Again, it's a great, but that's the type of thing we could discuss. It just doesn't exist.
Chairman Crawford.
For lack of a better term, so this is kind of like the wild, wild west. There's no licensing, there's no guardrails or anything to protect Tennesseans from this type of gaming, correct?
Mr. Gantz.
Thank you. VGW has implemented its own player identification and verification, age limits, responsible gaming limits. You can set how long you want to play. You can set how much you want to spend per week. So they're at the forefront, and there's no regulation requiring them to do this. They do that because it's good business and good policy. So many other forms of gaming are out there that have absolutely no type of restrictions. Video games that kids play, Madden, all the types of football games and baseball games, there's no limits on those, and people make purchases in those too. So we're not alone in being unregulated as a category in gaming and entertainment. There's no limit on how much Netflix you can binge watch. Another good example. So your concerns are good ones, and is part of the dialogue in society today, but we're not the only company out there that should be a part of that process and dialogue.
Thank you. Any further questions? Representative Carringer.
Thank you, Chairman. Yes, I just wanted to ask, because there's been so much on both sides, Toad and what's factual, what's not, and whatever. But the big thing that, did catch my eye and all, did you all receive a cease and desist letter?
Mr. Gantz.
I got it right last time.
Then I about missed it. Go ahead, Mr. Gantz.
All right. VGW did receive a cease and desist letter from, I believe it was Assistant Attorney General Jonathan Shirley a couple months ago. There was a process. There was a discussion back and forth, and VGW of its own agreed to voluntarily stop offering the sweepstakes services in Tennessee while reserving its rights if it needs to continue or go to court over these types of things. But VGW and other operators in the industry, they're interested in partnership and discussion, not litigation. And compliance with the law is of utmost concern. So when we get a cease and desist letter, it was taken very seriously, but we haven't had opportunity. And the next thing that came was this bill, which actually tried to change the law that we had received the cease and desist law under. And one last point about changing in the law that I'd like to make in response to your question is that when they wrote the cease and desist letter, there was nothing in the code that would attribute a totally free game with gambling. The definition of gambling in Tennessee has always been that you have to risk or stake something on a game of chance or a game of skill in search of profit. If you enter a contest for free, whether it's a hole-in-one contest or anything, it can't possibly be considered to be gambling under the code because it's free. But the new definition of online sweepstakes game, and I thought there had been some discussion about an amendment on this, but is that it includes now received through a bonus or promotion or received for free with the purchase of another type of currency. That runs contrary to established gambling law in Tennessee. And this equates, and I would note that the definitions also in what's proposed to be 47185901 defines gambling as having the same meaning defined in 3917501, which is where what I just read came from. Stake or risk in search of profit on a game of chance. That's gambling. Entering something for free is not gambling. So there's a conflict in the way that this is defined. It's a conflict with the gambling code. There's a conflict with the jury instruction for criminal gambling, and there is a direct conflict with the sweepstakes law, which remains unchanged.
Representative Carringer.
So, I mean, and that is a big issue for me, that our Attorney General would send something like that out, and we got a list of all these companies listed. So right now, like your company doesn't currently pay any taxes or anything to the state of Tennessee to operate or do the sweepstakes. And the amendment that was going around that possibly that took out the part of code to allow you all to do or carve out a piece, which, I mean, putting this all together, what does our law say? What does our law not say? And what is legal and what's happening legal? That we as a committee, or I would say myself, that I want to make sure that I make the right decision that upholds what our law says now as to what's been going on, to make sure that we're not just carving out something that is in law right now to make it legal for later or others. And so that is a big confusing part for me to try to understand and get which side we're going to go on this, because obeying the law and doing what our law says is a number one priority for me. And so I just wanted to let you know and to ask the questions is to try to see how we can get the answers on that.
Mr. Gantz.
Look, I think respectfully, we think the committee should pause on this, study this form of gaming, and consider ways other than a rushed legislative process to get to a point where there's a registration, to get to a point where the state could capture sales tax on freemium games, not just our product, but all these freemium games. People are spending tens of millions of dollars on these games. And this is something that can be subject to sales tax, and a number of states do. And where that is the case, VGW collects the sales tax, puts in the registration for sales tax, and does that. And, you know, the other thing that about confusion is that I don't think laws where people could be held to be in violating or be subject to a civil enforcement or be accused of gambling should be unclear. And as written, this is very unclear. It's problematic to say something that's free or free to enter is gambling. Just as a lawyer, I find that to be very conflicting.
Representative Martin.
I wanted to piggyback on Representative Carringer and ask our lawyer that question. I understand he's an advocate for his business, and I respect that. I don't disrespect that. But if we're going to get a legal opinion, I'd rather get it from someone who doesn't have a dog in the fight, so to speak. And so I would respectfully ask, Chairman, if our attorney could speak to that, the legalities of that.
Okay, we'll go out of session to hear from legal.
Thank you, Matt Mundy from Legal. Did you just, excuse me, Representative, did you just want to kind of understand the context of gambling versus gaming and the scope and within the parameters of this particular definition that we're discussing?
Representative Martin.
What I wanted to do was to understand from a legal point of view, does this law, if we pass this bill, is this going to violate our laws? And I think that was the point that Representative Carringer was getting to. And I want to hear from someone who is presumably neutral, and I'm assuming you are.
I try to be, thank you. It's good for job security. Matt Mundy from Legal. Let me just start big picture. Our Constitution prohibits gambling, full stop, except for education lottery. The legislature made the decision that playing in fantasy sports games and sports gaming was not gambling. And that goes to basically the three parts of the analysis for gambling by the Tennessee Supreme Court that goes back well over 100 years, that there's three elements that you have to find gambling. You have to have consideration, you have to have a prize, and it must be a game that's primarily risk-based versus skill-based. So consideration being something of value, then you receive something back, and the game has to be a game of chance, essentially. And so in the context of, for instance, sports gaming, it was determined by this General Assembly several years ago that sports gaming was a game of skill and that someone with enough information, same with fantasy sports, that they could make an informed decision as to how they wanted to place a wager on a sporting event. So to the speaker's point, if the game is free, then it's not gambling. If you are entering into something and it doesn't cost you anything, then it wouldn't be gambling, even if you may receive some prize or award for that. In the context of the definition, online sweepstakes game, as I read it, it says online sweepstakes game means gambling in the form of a game, contest, or promotion that. And then it has some subdivisions. But I would just say, when you say it means gambling, you're bootstrapping in that court analysis that's gone back 150 years, where you have to provide something of value to play the game that's a game of chance. And so when I read down in this, and it's one of the elements of this definition says play or participate with a currency, such as a virtual coin, token, or other representation of value that is directly purchased, received through a bonus or promotion, or received for free with the purchase of another type of currency or related product, service, or activity. So it seems to me, and I would happily defer to the Sports Wagering Council and the AG's office as to what their take on this is, but to me it reads that you are providing some consideration to play this type of online sweepstakes game by virtue of the definition. Now, they may disagree. It is a pretty convoluted definition, but I think that the way I read it and the statute that the speaker referenced in the Consumer Protection Act, I think can be reconciled so that a person can continue to enter something like a sweepstakes where you're not giving anything to play. Maybe you're dropping your name on a card into a box and you might get something, but you're not paying anything to do that. I don't read this definition to capture that, but they may have a different opinion. So you may want to ask them that same question.
Representative Martin.
Chairman, are they scheduled to testify?
They are here, and we will be glad to bring them up when questioning done with our guest currently.
Thank you.
Any further questions for the guest? Representative Miller.
Thank you, Mr. Chairman. A question, you mentioned,
Or is this for legal or for the guest?
not for legal, for the guest.
For the guest. Okay, we're back in session. Pardon? We out of we need to stay out of session. I'm sorry. Go ahead, Representative Miller.
Thank you, Mr. Chairman. You mentioned $25 a week that I guess these players spend. That was somewhat of an average. So that $25 average goes to VGW?
Okay.
Correct?
Mr. Gantz.
The median amount for users who spend, who actually make a purchase, over half never make any purchase anywhere on the platform. The median amount, so the average, is $25 a week. And yes, VGW is the operator. Of course, they have to pay payment processors and everyone else, so they don't get all of it. They have, like any other company, they have expenses. But yeah, that's like running an online game. You get the monies that come in. If it were taxable, you'd be taxable. I mean, I'm not an expert on sales tax and how it's administered, but if you collect sales tax, you'd be doing that at $25. That's the revenue. So whatever that percentage is, every transaction would do it. And, you know, companies that do not have a sweepstakes, for example, SciPlay, they run one, they're licensed gaming, they're related to licensed gaming. They actually have a site that nationwide did $900 million in revenue last year. 900 million. That's one platform operated by a company that's affiliated with licensed gaming. That's how big this market really is. Now, there hasn't been time to study any of that. And that's what we'd like to have further discussion about that.
Mr. Chairman, one other question.
Representative Miller.
So are you currently operating in the state of Tennessee?
Mr. Gantz.
As I mentioned, once VGW received the letter from the AG's office, they withdrew all of these sweepstakes games. But they have continued, like everyone else, all the freemium, because that's their real product is the freemium. They are still operating the same types of freemium games where people can make a purchase. They don't have to, but they're playing the same casino-style games that are across the board on all the platforms. They just aren't using the sweepstakes any longer to promote it. So they still have the same product as everyone else. They've just discontinued the sweepstakes. And of course, without prejudice to their legal position with the Attorney General's office in the state of Tennessee. But we'll, you know, that's why we're here. We want the law to change. We want to be regulated. We want to pay the sales tax.
Any other questions for Mr. Gantz? Seeing none, we're going to go back into session for just. Okay. Thank you, Mr. Gantz. Appreciate you being here. Do we have questions for the AG's office? I'm taking that as a yes. Okay. All right. If we could get a representative from the AG's office up here and okay. All right. Kelly and James, if you would just give us your names and who you represent and who would like to go first. Yep. You have 3 minutes and she'll turn your mic on right there in just a second. So who would like to go first? All right, sir.
Good morning, Chairman and members of the committee. JP Urban, Senior Deputy of the Financial and Regulatory Section at the Tennessee Attorney General's Office. I think the sponsor described the bill well, and I appreciate Mr. Mundy's description of the legal analysis as well. Largely agree with it. The Tennessee Constitution prohibits lotteries, and except for some exceptions. Now with games that are at least 50% skill-based, the legislature has the ability to legalize them. But many of the casino games that we're seeing today on the internet, roulette, slots, they may not be legalized under the Tennessee Constitution. And so in recent months and over the last year, the Attorney General's office has investigated many online casinos. We sent out, I believe, 38 cease and desist letters late last year, and all 38 of those online casinos ceased their offending operations here in Tennessee. We have a running list of hundreds more. I think 384 was the most recent count. And so there's really an online epidemic of these companies. And as you heard from the other speaker, that they're not paying sales tax, they're not regulated. It is an open online gambling world on the internet right now. And our office, tasked with upholding the laws and the Constitution, has been doing our best to enforce those laws. Now we do get pushback from some of these operators in an initial round of letter writing that argues against our position that this is gambling. And with one letter back, that take down their operations once we explain the state of the law in Tennessee, and we're happy to do that. And so this law simply clarifies what is gambling in Tennessee when it comes to these online casinos and these online sweepstakes models. They do their best to obfuscate the operations going on here. You have these dual currency models. You purchase, you get coins you can play free games with called gold coins. You purchase those. And for free on the side of that, you get a nearly dollar for dollar amount of something called sweeps coins. And you can use those sweeps coins to then win money. So it is, just an extra step to get to winning the prize. But any court would see right through that model and agree with the AG's office that is gambling. So we will continue to, enforce the state's gambling laws. But this law simply makes that job more efficient and helps us tackle the problem out there. And there are other provisions as well. And I don't know if my colleague Kelly would love to talk about those.
Thank you. Go ahead.
My name is Kelly Groover. I'm the Deputy Attorney General of the Consumer Protection Division in the Attorney General's office. And Mr. Urban's really here to speak about the gambling portion of the bill. So any questions about that he can answer. There are some other provisions in the bill, which I'm happy to speak to if anyone has any questions about those.
Okay. Do we have questions for our guests? No? Okay. Representative Miller.
Thank you. You mentioned, and of course, gambling is prohibited by our Constitution. Then you say other than lottery, which lottery is not gambling, correct?
You're recognized.
Thank you. Playing the lottery is gambling. It is risking a thing of value with a degree of chance for a prize. Our Constitution prohibits lotteries except for the Tennessee State Lottery and certain nonprofit lotteries. And so there are some carve-outs there. Now, lotteries are a type of gambling, but not all gambling is a lottery. And sorry to get fine points here, but there are really two categories of gambling. There's the lottery type where the result is more than 50% based on chance. And then there's the skill-based side where less than 50% of the result is based on chance. So you have, sports gaming, for instance, which this body legalized in Tennessee, heavily regulated, heavily taxed. Sports gaming, this body decided is more than 50% based on skill. So the Constitution allows that to be legalized, whereas slots, casino-style games like slots and roulette and the like, may not be legalized through legislation of this body without a constitutional amendment.
All right.
Answered that question.
Miller.
My next question is, how many states currently allow for this particular platform, VGW? How many states?
Thank you, Chairman. I don't know the answer to that question. I know that that across the country, many states are cracking down on online casinos like this, like VGW and many others. And so we are just a part of that at this point. There are certain states that allow casino style gambling, but I don't know for certain the number. But I'd be happy to get back to you with that.
Thank you. Is any further questions? Seeing none, thank you all for being here. And we are going back into session, and Chairman Crawford, you're recognized.
Thank you, Mr. Chairman, and I asked for a little leeway for a few questions for the sponsor. The first guest we had that spoke, he was reading from an amendment. And I looked through the amendment that we placed on the bill. I didn't see any of that wording. Is there other amendments out there that that hasn't been presented, I guess?
No, Chairman Speaking.
Yes, Mr. Chairman.
Okay. Well, to be honest with you, Mr. Sponsor, I'm really kind of concerned. I'm concerned with not having any guidelines on this, and I'm concerned that we are possibly doing something illegal or legal. But since there's other amendments in the discussion that the committee is having, I'd like to make a motion that you roll this week.
Chairman Speaking, we have a motion and we have a second on a roll for 1 week.
Can I request a 2-minute recess?
Pardon?
The two-minute recess, Mr. Chairman.
I'm sorry that it would have to be a motion by the committee to recess. So
I'd make a motion that we roll his bill to the hill of this calendar, and let's get some other things that way. They can go do their talking, and we
do need to move on. Yes, we
Right.
do.
We can get some other stuff done.
All right, we have a motion to roll to the heel of the calendar. We already have that. Okay, we do have the motion that's presented to roll it for 1 week. We'll need to deal with that. We'll vote on rolling 1 week. Anyone in favor of rolling 1 week? There, say aye. Aye. Any opposed? Bill's rolled 1 week. Thank you. Next up is Chairman Clemens. I'd say everybody's loosened up on that one. So
let's let this room clear out before we go.
House Bill 1768 by Chairman Clemens. Do I have a motion? We have a second? We have a motion and a second. Chairman, you're recognized.
Well, thank you, Mr. Chairman. I appreciate the attention to this matter. I'll try to be a little bit faster than that last piece of legislation. I think this is my inaugural visit to this committee, so it's an honor to be here with you. What this bill would do would simply prohibit sports wagering on campuses of public institutions of higher educations and at sports venues on the day of the sports or sporting events. And it would require our public institutions of higher education to limit access on their servers to sports wagering sites. What we have done here, we have tried to be measured in this, but I'm trying to address multiple issues with this legislation. One, address the alarming rise in sports betting among college students, which is costing families and the students themselves a lot of money. As you all know, we save up for our child's education. Our state invests money into children's education in the state of Tennessee, and we want that money used for educational purposes. The other aim of this is to protect those family savings and investments in higher education. And the third is to seek to limit the rise in harassment and assaults of student athletes on college campuses. And I've provided you all with a memo here a couple of weeks ago. I'm not sure if you still have that or not, but it has a lot of statistics on there, and I'll just highlight a few of them. One, with regard to the rise in sports betting on college campuses, NCAA has done a tremendous amount of work on this and spent a lot of research dollars on this because this has become such an issue. 58% of young adults across this country, ages 18 to 22, have said they have engaged in at least one sports betting activity. It's widespread on college campuses. 67% of students living on campuses are bettors and tend to bet at a higher frequency. 41% of college students who bet on sports have placed a bet on their school's teams. And 35%, of course, have done the old way before we legalized it using a student bookmaker. This is a real problem that is growing. Up to 75% of college students reported gambling in the past year, according to a November 25 update of that NCAA poll. 1 in 10 of those show a sign of a gambling disorder, according to the National Council on Problem Gambling in their 2025 report. The next, with regard to protecting investments of families and the state of Tennessee, use of financial aid has become prevalent among sports bettors on campuses. 21% of college students have admitted to using financial aid or student loans for gambling. This behavior diverts essential funds from tuition, housing, and food, as you know. There's a plethora of more data with regards to this. Addiction risk on campus are increasing. College students are highly susceptible to gambling addiction due to their age, social influence, and the accessibility of betting platforms on campuses. Brain development, as you know, of those ages, college-aged who legally gamble are still developing, the parts of the brain responsible for impulse control and decision-making. And then with the third prong, to prevent harassment and assault of student athletes. This is a huge issue that's growing. I've got another piece of legislation to protect student athletes on campuses, but to the extent people are betting on their college campuses and their college games, this is causing them to put more undue pressure on student athletes. 1 in 3 high-profile athletes receives abusive messages from someone with a betting interest today. NCAA's 2025 Growth Opportunities, Aspirations, and Learning of Students in College study found that 51% of Division I men's basketball student athletes reported receiving social media abuse based on their athletic performance alone. The group also reported the highest rates of receiving negative or threatening messages were from someone who bet on their game at 46%. Now, what's interesting is women have reported receiving higher percentages. So people are betting on women's athletics as well. And they actually, a few years ago during the March Madness, received 3 times as many threats and abusive messages against them. Sir, as I've said, we can go on with the statistics that supports this, but all we're simply trying to do is limit college betting on campuses, prohibited on college campuses. Sports betting and gaming apps have the ability to geofence around college campuses and contiguous properties and even satellite properties to the property line. And then, of course, we have banned certain websites or social media sites from college campuses in the past, and they have the ability to do that. So that's what we're seeking to do.
Okay. Thank you for the. Is there a question for the sponsor? Yes, Representative Martin.
Thank you, Representative Clemens. In the history of higher education in the state of Tennessee, have there been sins that have been banned by policy that's been enacted by the trustees or the president of the university as opposed to a state law?
Chairman Clemens.
Define sins.
Well, we could say gambling would be one. We could say drinking, fornicating. I'm just thinking about the history. Has it always been a law, or have we banned certain things by policy from the trustees and the president?
Chairman Clemens.
I don't know that I'm following your question, but I think it's fair to say that we have the jurisdiction to limit what happens on public institutions of higher education to the extent we want. And I would argue, I would dare say that universities have prohibited certain activity on their college campuses. For instance, with regard to one of your examples, certain dorms don't allow members of the opposite sex into the dorm past 10 p.m. Certain fraternities go on probation and aren't allowed to have alcohol on site. I don't know exactly what you're asking, but those are just examples of the type that you've provided.
Representative Martin.
And I would say that if a university, if this bill fails and a university wanted to enact, in essence, what you're saying, the geofencing where it couldn't be done on campus, the university could do that without this law. Would that not be a true statement?
Chairman Clemens.
That's an interesting question, one that I don't necessarily know the answer to, and I'm not positive that they could.
Representative Martin.
You speak about the students and the challenge with students, but there are more than students on a campus. There are professors, there are fans, there are other people that are there that would be prohibited. It's not just the students. Is that a true statement?
Yeah, that's actually accurate, and is part of the intent of this as well. Now, if you look at the data, and what supports is there's a spontaneous action among those in college, those college-age students. If they're sitting in their dorm, that decision to place a bet, is a spontaneous reaction. So to the extent you would make that student get up out of their dorm room or their apartment and walk down the street to take that extra time to get off college campus to place that bet, that dissuades them. The rates of gambling on college campus among students would drop, and I think that would be a good thing, according to the data. Now, the other part is you're talking about things that go towards fans at a stadium on game day. You're talking about fans walking across campus who are attending a game, or even professors on college campuses. And that would also be prohibited because we don't want that to be an environment where it creates a threat of harm to those student athletes. So that's one of the other prongs of this. So if you can't place a bet spontaneously on a game, whether you're a fan or college student or a professor, and you're at that sports venue, you're less likely to harass a student athlete based on your betting interest in that game. And that accomplishes one of the aims that we're seeking to achieve here.
Representative Martin.
I would just say this. I appreciate what you're trying to do, Representative Clemens, but I'm going to vote against the bill because I think just in real world, the way this is going to play out is you're going to have a bookie somewhere on Cumberland Avenue sitting at a restaurant, and they're going to text him from the dorm or for the fraternity and say, hey, I want $20 on Kentucky. Well, nobody wants to bet on Kentucky, but they're going to make those bets. And so you're going to be having the bookies that are going to be doing it legally on Cumberland Avenue as opposed to being on campus. And I don't know that that is a good thing. And so I appreciate what you're trying to do. I really do. I get it. But I think there's some unintended consequences that I'm just not comfortable with. And that's why I'm going to vote no at this juncture. I'm done.
Thank you. Chairman Clemens.
Yeah, thank you, Mr. Chairman. And I appreciate that. And to think that this would result in bookies would be a misstatement. Bookies have always been on college campuses. Let's be honest about it, even before we legalized sports gaming. So we don't have any jurisdiction as a body to regulate things that are happening illegally. We don't have any way to do that. Things are going to happen illegal if people choose to act in a legal manner. We can try to crack down on them. We can try to, fine them and criminally punish them as the laws allow, but we don't have an ability to regulate them in this manner. So if there's a bookie sitting in a fraternity somewhere or a sorority house, that has happened for decades. I don't know how much time you spent around college campuses, but that's just a reality. What we have the limited ability to do is try to decrease the rate of sports gambling among college students and those around and on college campuses for the protection of our hard-earned tax dollars that we're investing into financial aid and lottery scholarships and the like, that we are saving up as parents, putting into savings accounts to send our children to college where we don't have to worry about them? Or are we going to eliminate the entire possibility? No. But can we decrease the likelihood of them spending your hard-earned money and taxpayers' hard-earned money on a gaming app that's in the palm of their hands and that is lightning fast, just like that they can currently do sitting in the dorm room or anywhere on campus? We don't want that. And so that's what we have the ability as a state to prohibit. And this goes as far as we are allowed under our jurisdiction. If you're licensed, then we can regulate you. That's what this seeks to do. And do we have jurisdiction over public institutions of higher learning? Yes. Can we require them to cut off access on their servers? Yes. That's all this bill seeks to do.
All right. Any further questions for the sponsor? Okay. Chairman Powers.
Yes, thank you, Mr. Chairman. One quick one. You were talking about cutting off the servers. So if you're not on a server, if you're actually just using like a Verizon or AT&T or whatever direct thing, would it affect that too? I mean, could that be cut off too?
Well, that's why we would have
Chairman Clement, yeah.
Around the real property, which they have the technology to do. They could geofence around this building to where you couldn't access it. That's the second part of that bill.
Okay. All right. Thank you. Any further questions? Representative Miller.
Thank you, Mr. Chairman. I support the legislation. I think it's a beginning. At some point in time, we're going to have to get some control and some type of control over this, whether gambling pandemic or, we have to. And this may be the best place to start. So I support it.
Thank you. Any further questions for the sponsor? Seeing none, Madam Clerk, if you would, open the board for voting. Has everyone voted? Anyone wish to change their vote? Not, Madam Clerk, take the vote.
Mr. Chair, you have 3 ayes, 4 noes, and 0 present not voting.
Chairman, your bill fails.
Thanks, sir.
I'm sorry.
Appreciate your
Thank
committee.
you. Okay, next up, item number 10, House Bill 2220 by Representative Alexander. We have a motion. We have a second.
Second.
We have a motion and a second, and Representative, you are recognized.
Thank you, Chairman.
And I'm just glad that it's not dealing with gambling.
I am too.
All right.
I definitely am too.
But I do see you have an amendment. Is that correct?
That is correct.
And it does rewrite the bill.
Yes.
So without objection, we'll go ahead and get that amendment on the bill. Okay.
And I believe that's 011073.
Not
Is
what
that
I'm
the right one, or did I pull up the wrong
not
one?
the one I'm seeing. I'm seeing 13462.
Okay. Yes, sir.
Okay.
I'm sorry.
Okay. So we have a motion on the amendment. We have a second. All in favor of adding the amendment to the bill, say aye. Any opposed? The ayes have it. The amendment is on the bill and you are recognized.
Okay. Thank you, committee. Basically, in the past, our Tennessee Arts Commission has had 15 members, all appointed by the governor. And so this newly constituted commission will have also 15 members, with the governor appointing 1 member from each of the 9 congressional districts, the Speaker of the Senate appointing 1 member from each of the 3 grand divisions, and the Speaker of the House appointing 1 member of each of the 3 grand divisions. This would just take some pressure off the governor to appoint everyone and spread it out a little bit.
Okay. Heard the explanation. Is there any questions? Seeing no questions, Madam Clerk, if you would open the board for voting. Has every member voted? Anyone wishing to change their vote? And Madam Clerk, if you would announce the vote.
Mr. Chair, you have 7 ayes and 0 noes.
All right, Representative, you are moving on to full state and local.
Thank you, Chairman. Thank you,
Thank you.
committee.
Next up is item number 11, I'm sorry.
Yes, Mr.
Representative Miller.
Chairman, out of order. May I recognize Alderman Kevin Grant from Bartlett, Tennessee?
Yes,
In my
absolutely.
district. Just wanted to recognize that I saw him walk in.
Absolutely. Glad to have you here. All right. House Bill 1815 by Chairman Russell. We have a motion. We have a second? We have a motion and a second, and Chairman, you are recognized.
Thank you, Mr. Chairman and committee. I do have an amendment that makes the bill.
Okay, and that drafting code is?
I show 014470.
That's what we have. Motion on the amendment and a second on the amendment. All in favor of adding the amendment, say aye. Any opposed? The ayes have it. The amendment goes on the bill, and sir, you're recognized.
Thank you, Mr. Chairman and committee. House Bill 1815 as amended authorizes the operator of a jail to refuse an arrestee if they have not received obvious required medical attention, requires the arresting agency. If a jailer refuses to accept an arrestee to have them evaluated by a healthcare provider, requires the jail to accept the arrestee if a medical provider releases the prisoner. With that, I renew my motion.
Heard the explanation. Chairman Crawford.
Move previous question.
Previous question has been called. Madam Clerk, if you would, open the board for voting. Has every member voted? Anyone wishing to change their vote? Madam Clerk, if you would, announce the vote.
Mr. Chair, you have 7 ayes and 0 noes.
Chairman Russell, you're moving on to full.
Thanks.
Thank you.
Don't see Representative Boyd's here.
All right, we're going to move to item.
Take up 15 first.
We're going to move to item 15 by Chairman Boyd.
Just so he can, since he came in to testify.
Okay.
We'll get him out of
Okay. What's his name again?
here. Tim Leeper.
Tim Leeper. Okay. Chairman, we have a. Okay, we have a motion and a second. And you're recognized on House Bill 2111.
Thank you, Mr. Chairman. I do have an amendment. And
Okay.
it's amendment drafting code 014374, Mr. Chairman.
That is correct. All right. We have a motion on the amendment. We have a second. Do we have a motion? We have a second.
Mr. Chairman, committee members, House Bill 2111 would create a state family advisory board to support and involve families of incarcerated individuals in matters that affect their loved ones. It would be comprised of 9 members appointed by the governor, the Speaker of the Senate, and the Speaker of the House. They would meet quarterly, and they would be equally divided between the 3 grand divisions,
Okay.
Mr. Chairman.
Okay. We do have someone who is signed up to testify on this. Is Mr. Leeper in the room? Okay. If you would come up and take a seat, please. We'll go out of session to hear from you. And if you would, when you take your seat, your mic is on, I think.
Yes, sir.
And if you would just identify yourself and if you're representing anyone in particular.
Yes, sir. Thank you very much. I am Tim Leeper.
3 minutes, sir.
Yeah, we're going to forego the whole 3 minutes. We've
All right.
got things to do.
All right. Thank you.
I appreciate this committee's time. Tim Leeper with Kylan Slide as the executive director. I just hope that this bill could serve as a liaison between the families who don't get very good communication from the TDOC and have a large level of anxiety. And so I could give you all the reasons why we need this bill, but I think that hopefully it speaks for itself. And so I appreciate your time, and I want to yield my time back to the committee at this point.
Thank you. Is there any questions for our guest? Seeing none, Mr. Leeper, thank you for being here. And we're back to Chairman Boyd, and we are back in session. So Chairman, you're recognized.
Nothing further at this time. Just
All
ask
right.
passage to full committee. Thank you, Mr. Chairman.
Thank you. Is there any questions for the sponsor? We have Representative Chisholm.
Just a quick question. Did we run this bill last year?
Chairman Boyd.
Thank you, Mr. Chairman. No, this is a first of a kind.
Okay.
Thank you.
Any further questions? Seeing none, Madam Clerk, if you would open the board for voting. Several member voted. Anyone wishing to change their vote? Seeing none, Madam Clerk, if you would announce the vote.
Mr. Chair, you have 6 ayes, 0 noes.
All right, Chairman, you're moving out to state and local full.
Thank you, Mr. Chairman.
Thank you. We are. Oh, okay. All right. We're going to go ahead and get your other bill then in here. 1914, House Bill 1914 by Chairman Boyd. We have a motion and a second. You're recognized.
Thank you, Mr. Chairman. This is a terrific bill. It's brought by the State Veterans Home. So if you didn't know, we actually have 5 veterans homes in Tennessee. A 6th one is under construction. They care for about 500 veterans. And this bill would simply expand their services a little bit to align with what the VA is wanting to do in the next few years. It would allow them, it would not make them do it, but it would give them the capacity to offer home health care, adult daycare, some outpatient procedures like physical therapy, occupational therapy, and speech therapy. And that's what it does, Mr. Chairman.
All right. Thank you. We have Chairman Crawford.
Move previous question.
Previous question has been moved. Madam Clerk, if you would open the voting board. So every member voted. Anyone wishing to change their vote? Seeing none, Madam Clerk, if you would announce the vote.
Mr. Chair, you have 6 ayes and 0 noes.
Chairman, you're moving out to full state and local.
Thank you, Mr. Chairman.
Thank you. That's a good bill. Thank you. All right, folks, we are up against a hard stop, and I see the rooms filled up with the next crew. So without objection, we stand adjourned. Nope. Oh, I'm sorry. I do need to take care of rolling the remaining bills on this calendar to the next available calendar. All right, now we stand adjourned.